Hello, I'm Judge Krister Thelin, and I'm Sweden's candidate for the International Criminal Court with the support of the other Nordic countries. And I will now share with you some of my reflections on the court. From my perspective, the importance of the International Criminal Court is in establishing the ICC some 15 years ago. It was a major step in combating impunity and prevent serious crimes at an international level, where national institutions are unwilling or unable to cope. An important factor was that the International Criminal Court give victims standing and a say, unlike the practice of the UN tribunals of the former Yugoslavia, ICTY, and Rwanda, ICTR. And in the over 11 years the ICC has been operating, it has developed international criminal law and procedural law, while also, of course, drawing from the jurisprudence of the ICTY, the ICTR, and other temporary or international special criminal courts. The International Criminal Court has come to stay and will continue to grow in importance, despite the criticism which is at times leveled against it. What challenges are facing the court today, and what means are there to address them? Well, firstly, the paramount concern should be to bring justice to accused and victims in a timely and fair manner. It would seem that cases are dragging out unnecessarily long, and as we know, justice delayed is justice denied. And as an outsider, albeit a somewhat informed one, it would seem there are many and at times valid reasons for this. The investigatory phase is mainly outside the scope of the judges, and it is very little they can do to push the prosecutor in expediting this part, nor is it for the judges to choose what investigations to open. And secondly, there is a need to underscore the important division of functions between the prosecutor's office and chambers. They are technically and administratively both part of the court, with the registrar as the third component, but should be kept apart conceptually. This is not seldom forgotten, and acts by the prosecutor are at times attributed to the court as such, with the obvious risk of compromising the important principle of presumption of justice. And these misunderstandings could be remedied by always clarifying what part of the court is in fact acting or speaking. There is a challenge here, not the least for media, to inform the public at large. And thirdly, existing rules, regulations, and practices should be used to maximize and optimize case management. That is, to make sure that the cases are dealt with the utmost of efficiency, without jeopardizing fairness or due process. Modern techniques, for instance, video linking, should be further developed and used by the International Criminal Court to this end. And judges should always be ready to review existing practices in order to streamline and uniform where differences have emerged, and, as appropriate, suggest and adopt amendments. Finally, you must recognize the international dimension of the investigations and trials, which make them more expensive and lengthy compared to the ones in national courts. The court is often depending on other countries and their cooperation. Legal translation takes time and requires high quality in order not to jeopardize a fair trial. So, why have I agreed to stand as a candidate for the International Criminal Court? Well, I do it because I believe I can make a contribution to the court, its mandate, and its administration of justice. With my domestic and international experience as a judge, not the least my 5 years as a judge at the ICTY in The Hague, I believe I, within the limits of what one colleague of many could accomplish, could assist in further developing the court in administrating international justice. It is an important, humbling, and legally historically important task. My background in the United Nations Human Rights Committee has in this regard, in my view, added value, since it brings the dimension of human rights to the humanitarian law. Also, the Nordic countries have from the outset in the court's life been lending its political and financial support, including contributions of legal professionals. I also believe that the Nordic legal tradition has its place in the blend of different legal systems that are represented in the Rome Statute and in the court rules and regulations. My experience from being a Swedish judge would be particularly valuable, as Sweden is seen as a halfway house between a common law and civil law system. Finally, I look forward to again having The Hague as my place of business. Both my wife and I enjoyed our years there while I was at the ICTY. Thank you.